they'll just pick up from where they are. So welcome everyone, and thank you for joining us, whether it's afternoon, evening, or night. My name is Farah Hossain, and I will be moderating the session today. Our discussion today is on employment law considerations. And I just want to tell you a little bit about how we're going to run it. The format of today's session will be as follows. We will have a brief presentation by both speakers to establish context for the discussion that we're having, and then we'll move into addressing specific topics that you raised over the past week. For those of you that weren't able to send in questions ahead of time, I invite you to submit questions live by using the Q&A button on your screen. I will do my best to answer each of your questions or to raise each of your questions during the session. But if we run out of time, both of our speakers have committed to responding personally to each one of you whose questions were not addressed. Note that when you're asking a question live, there is an option to choose an anonymous question or a question where you identify yourself. If you choose the anonymous option, we will not be able to respond to you. So I just want to let you know about that up front. Now we can get on to the main discussion. Today, our session centers on the topic of employment issues. As you return to active practice, if you're a dentist, one key element you have is bringing your staff back safely and efficiently, and doing so will help ensure continuity and your practice's long-term value. We asked you to send in your questions ahead of time, and there was an enormous response. That indicates to us that employment matters are occupying a large space in your minds at this point in time. We aim to resolve many of those questions today, or at least to give you some context for how to deal with them going forward. And without further ado, I want to introduce our speakers. Our first speaker is Paul Martin. Paul, can you wave your hand? He's not to be confused with our former Prime Minister, and by no means does he resemble him, but I just wanted to say that. Paul is a founding partner of Wilton Martin Litigation Lawyers, and he provides civil litigation representation and advice on a broad range of matters to dentists, with a particular emphasis on employment and labor law, commercial litigation, professional discipline, and health law. Our second presenter is Bill Henderson. Bill, give us a wave.
First
there you
presenter.
Go. Bill is the president and principal partner in Tier 3 Brokerage, which is one of Canada's leading dental practice brokerages. Many of you know Tier 3 already, but we manage over $50 million in practice transitions a year across the country. What I'm going to do now is get Bill to give you a quick update on practice values as well as important factors that you need to consider as you return gradually or fully to work. Then we'll give the floor to Paul to address the questions that we received. Bill, I'd like to hand it over to you now.
Oh, thank you, Farah, and welcome everybody. My comments tonight are going to be pretty brief. You can jump to the first slide there, Farah, because many of you tuned into a webinar I did with Mark McNulty a couple of weeks ago, where I talked in depth about what's happening with practice valuations, and some tuned into the Henry Schein one a while ago. And I'll give you a bit of an update, but most of you are here to hear Paul Martin, so I'm going to be pretty quick today. If you missed some of those previous webinars, just email Tier 3 or email me, and we can send you links to them, because I'm going to touch very briefly on some of the things I talked about in those sessions, but only briefly. The key question we're getting is, hey, what's happened to practice values? What are the implications of this on my net worth? And what I said a couple of weeks ago when we did the session is that we're right now in a period of extreme uncertainty. But and this was the slide from the presentation, most of you are looking at going, Bill, I've seen this. But I talked about the fact that as time goes on, we're going to slide down the uncertainty curve, and people's confidence about what the future holds will grow. And that's going to move us from a time of extreme uncertainty and volatility in terms of dental practice values towards a much more stable environment again. And those of you who've tuned in to the sessions know that we really do believe we will get back once we hit the new normal. Best guess at this point is to values that are very consistent with what they were coming into COVID. But we've got this period of uncertainty. The next slide is just a little bit of an update, because what has happened, 2 weeks ago I said time will reduce uncertainty. Well, time is already starting to reduce uncertainty. You know, there've been major developments in the last couple of weeks, and the practices are now reopening in many provinces. Not everywhere, but in many provinces. And there have been very definitive guidelines issued in other provinces, the most topical of which is the extremely onerous guidelines that came out in Ontario on Friday. And we'll talk a little bit about that, but not much. But the key thing is we're starting to see what the return to business will look like. In terms of where we're at right now, the situation has not changed in that we came into COVID with about 7 deals where there was a price on the table, either in a letter of intent or in a purchase agreement that was being negotiated back and forth. But it wasn't signed before March, the infamous March 16th. Those deals all are sitting there ready to proceed, theoretically at lower prices than they were. But of the 7, 5 are still scheduled to move forward above the appraised value. That's the key. So we've seen on average about an 8% drop in the price, but that was from premiums well above appraised value. Now, the problem is none of those deals have closed. And a major consideration in all of those deals, part of the answer came on Friday with the RCDSO announcement, but the most important thing to getting those deals closed is going to be purchasers and bankers confident that revenue is going to return. We all know that PPE costs are going to be exorbitant for the next 3, 6, 12 months until global supply catches up with global demand. Then they'll return to more normal levels. You'll be using more of it, but our belief is, and everything we're hearing is, the various provincial regulatory groups will be, or not regulatory groups, associations will be adjusting fee guide, and they're all in discussions with the insurance industry now about that. So we think the earnings will generally, the cost picture will be fine. The big question is revenue. And the key thing you can do if you want to sell your practice in the next year or so is demonstrate a very rapid return to previous revenue levels. That's going to be challenging, particularly with the latest RCDSO guideline in Ontario and some of the things going on in Quebec and Saskatchewan. Just a teaser, the whole issue of air changes per hour and fallow time. We've made arrangements with Canada's leading air quality monitoring company, or one of Canada's, with regional operations. Literally, they've got 2 on Vancouver Island right through to Newfoundland, and a leading academic at the University of Toronto. And we're going to be doing a webinar. We're rushing it because it's so topical for many of you. We're going to be doing a webinar on Friday. We'll get notice out to people, right, Farah, as soon as we've got the details confirmed, but we're hoping Friday at 1 o'clock. Is that where we're at now? She's nodding her head.
That's where we're sitting right now. Yeah.
Yeah.
Yep.
So the most important thing every one of you concerned about your practice value can do, and this is equally true for your earnings, even if you're not in a short-term sales situation, is get the revenue going as fast as possible. So we're going to be doing a series of these webinars focusing on inviting a few experts like Paul Martin to help you through some of the key challenges in getting back to business, getting your revenue back up to restore practice value. So those were my comments. If you want more detailed comments, the next slide, we've got people coast to coast across Canada. If you want some more specific commentary on your local market, by all means, reach out to one of them. You can find them on our website. Oh, sorry, I skipped my Tom Cruise slide. I've talked to this, I just didn't jump to the slide. Far and away, the most important aspect of rebuilding practice value is going to be ramping up revenue as fully and completely as possible. And, you know, it is the Jerry Maguire line: buyers, their advisors, and their bankers are going to want you to show them the money. And if you can do that, we will see values bouncing back very quickly. If you can't do that, it's going to be more challenging. So talk about burying my best slide. On to the next one. So the next slide just shows what I was saying, which is we've got experts right across the country. And if you want to talk about what's going on in your market, feel free to reach out to any of them. Other than that, at this stage, I'm going to turn things over to Paul Martin, simply based upon the questions. I've been joking with him that, you know, I'm going to be that guy at the high school dance sitting over in the corner where all the girls surround Paul. Because you all came to hear him, so I'm going to turn it over to him now.
Bill, I've never known you to be a wallflower, so this will be a new experience for me. Sorry, just a few technical difficulties as usual.
There you go. You're up.
Okay, good. We worked it out. Okay, so thank you for having me this evening. As Bill and Farah had alluded to, I'm going to have a quick discussion about where we stand right now and what has happened over the last little while with dentists and their employment situations. And then we're going to open up the floor for questions. So I want to just quickly go through, as I said, what has happened in dentistry over the last, and I can't believe I'm saying this, almost 11 weeks. So as you know, across the country, the dental regulators, for all intents and purposes, stopped dentistry from moving forward as of about March 15th. And so that dentists were only able to provide emergency services. Certainly there are emergency clinics that are open, but for the majority of dentists, they've been effectively closed since March 15th. What happened in the wake of that is that employers laid off their employees en masse. Okay, I would venture to guess that 98% of my clients laid off all of their staff members once this hit. And you know, there were options available at the time that we would explore with our clients, and those options were essentially to lay your staff off or to leave them on pay, and to see what happened over time. For the vast majority of dental employers, it simply wasn't practical for them to leave their staff members on their payroll during that period of time because there was no flow of cash, okay? And that, you know, it would require most dentists to dip into their own savings to keep staff members on payroll. So for that reason, the majority of dentists laid off their staff members within about a week of March 15th. You know, some held on for a couple of days, but for the most part, it happened during that week of March. I think 16th was the Monday to the March 20th. And again, just a point about that, and most people who are watching are probably well aware of this at that point, or at this point, but a layoff does not mean a dismissal. Okay, a layoff is a statutory mechanism contained in the employment standards legislation in all provinces, or most provinces, that allows the employer to place the employee on a temporary suspension of work, but it doesn't sever the employment relationship. And so that's the reality for many employers right now. As most employers will also know, that subsequent to the pandemic hitting, the emergency, or the CERB was released by the federal government. That has morphed a little bit since it was initially released, but we're now at a point where it's pretty static and we know how it works. So essentially, employees who don't have work due to COVID-19 will earn $500 per week for a maximum of 16 weeks. And this is open to employees until October. So it doesn't mean that the benefit runs until October. It means that they get 16 weeks from the time it was announced until October. So they can jump on and off it. And one of the key changes that came to the CERB after it was initially announced is that employees could earn up to $250 per week or $1,000 per CERB period, and it wouldn't impact their entitlement to the CERB. And this has created, I would say, some confusion, actually to say the least, in terms of how the CEWS and how the CERB can be utilized in conjunction with each other. And that's, for the most part, a major question that I've been receiving from all of my clients over the last several weeks, is how the CERB and how the CEWS interact with each other. And as an aside to that, all employees, whether you know this or not, all employees have been transitioned to the CERB. So even those employees who initially were receiving EI when they were laid off on March 16th and accessed EI benefits immediately were moved over to the CERB at some point shortly thereafter. So the EI system, it still exists for employees who might have been on EI prior to COVID, but for anyone who lost their job due to COVID, they're now on CERB. Subsequent to the CERB, the federal government also announced the CEWS, the wage subsidy. And I've heard a number of different iterations of how that acronym is pronounced. I've heard the Qs, the SUs, and from some, the CHUs, but I'm just gonna call it the subsidy. Okay, so the subsidy allows employers to call employees back onto their payroll and receive a subsidy for the wages that they pay to the employees. It's open to all employers in Canada for the most part. And in order to access that program, employers needed to show a drop in earnings. And basically, it was a drop of 15% in March over the year previous, and then 30% in April and May. You could also look at January and February of 2020, and then take those 2 months in conjunction and then apply that or compare it to March, April, and May. But for the most part, it's 15% or 30 and 30%. And the intention of the CEWS was for employers to call employees back off of that layoff so that they maintain that working relationship. Okay, and this has now recently been extended to August 29th, which is a very important point to keep in mind. Initially, it was to run till June 6th, but just I think it was last week or late in the week before, the government announced that it's going to run to August 29th. They haven't announced as of yet any changes to the CEWS subsequent to June 6th, that initial end period. I've been hearing that there are changes in terms of who might be able to access it, but there doesn't seem to be any changes in terms of how it functions. And again, there's a process with this. So this is not an employee benefit. This is an employer benefit. The employee is paid by the employer, and then the employer will apply to the federal government for the subsidy. And it's quite simple. For those of you who have accessed it, you probably have found that it takes about 10 to 15 minutes to run through the portal on the My Business account with the CRA. It's not rocket science. There are some little complicating factors in the way that it practically works out, but everyone seems to be able to figure it out. And then the subsidy is paid directly to the employer for the money that they pay to the staff members. It's determined on the basis of the wages actually paid to the employee. And as dental clinics start to open and you start to call your staff members back, you'll still be able to access the CEWS. And at that time, you'll have a determination to make in terms of how much you're going to pay your staff members. And I'm sure that we're going to get into that question a bit more after. So again, this is just a bit of a State of the Union address, and then we'll deal with more of these items in the questions as they come. The EI and CER benefits in the same week as the CEWS, so accessing them at the same time. This seems to be a large point of confusion out there as well right now, in that people think that if you get the CERB, you can't, or if your employee gets the CERB, then you won't get the CEWS for any wages that you pay to your staff members. And I think that that's a fiction. That's not true. That's not the way that these programs interact with each other. So the calculation of the CEWS, I think everyone probably knows this by now, but I'll just reiterate it. The employer will get 75% of the pre-COVID earnings paid to the staff member. And the maximum subsidy is up to $847 per week per employee. Now, what has happened over the last several weeks as the CEWS became accessible for dental employers is that dentists were asking a lot of questions about, well, I don't have the extra 25% to pay to my staff members. I don't have any income coming in whatsoever, so I don't feel comfortable dipping into my own savings to pay that 25%. Do I have to pay it? And my advice to dentists is probably not. Again, it's not legislated that the employer, any employer for that matter, has to pay the 25%. But if you look at it this way, these programs or this program is available for employers who had a dip of 15% in revenue in March and then 30% in April and May. So that contemplates businesses that were earning 85% and then 70% of their pre-COVID earnings being able to access this system. If anyone has to pay that additional 25% on top of the 75%, it's those businesses. I cannot envision that the federal government is going to turn around the CRA at some point in the future and look at dentists and say, well, listen, you know, you had it great for a number of years leading up to COVID. And for that reason, you know, you had to mortgage your home to start paying the 25% to your staff members. I simply don't see it. And I don't think that any dentist who has only paid the 75% is going to be penalized. And so the way that that then works is that if you only pay your staff members 75% of their pre-COVID earnings, the government will actually end up reimbursing you for 100% of those amounts paid. And that's for the most part what almost all of my clients are doing at this point. And just to keep in mind, pre-COVID remuneration is based on the period of January 1 to March 15th. So what you would do, or what you would have done, is you would have looked at what each individual employee earned during that time frame, which gives you an average week once you divide it by the not so round number of 10.7 weeks. And that's how you come up with the pre-COVID earnings. And then you analyze or look at that number and you determine what you're going to pay your staff members based on that, so that you can access the CEWS program to the maximum amount available. And so, for instance, if you have a high-earning hygienist who has a pre-COVID weekly earning of $1,500, if you can't pay that $1,500, what you would do is simply pay that person $847. And that's 75% or is less than 75% of their pre-COVID earnings. So the government would reimburse for 100% of that amount. And then similarly, if you had someone with pre-COVID earnings at $1,000, if you can only afford to pay them the 75% so that you get reimbursed at 100%, you would give that person $750 and the government would reimburse you for that full amount. It's important to keep in mind that with the CEWS, there is no work requirement. So the whole program contemplates a paid leave. And in dentistry, that's the reality for the most part. There's simply not a lot of work to go around, or there hasn't been a lot of work to go around over the last number of weeks. So for the most part, most dentists who are utilizing this program are calling their staff members back and simply keeping them on a paid leave. And the reason that most of them are doing that is so that those staff members who were on a layoff are no longer on a layoff. This program, once you call them back onto it, so long as you run the numbers appropriately, your staff members will no longer be on a layoff from their employment. And one of the big questions that we've been getting, and we're going to deal with this a little bit later, I think, but is the question of what do I do if my staff members are on a layoff and that layoff period is about to expire? And the simple answer to that will be, and I'll illustrate this a little bit more later, is utilization of the CEWS. And in terms of the paid leave, if your staff members are not doing any work and you have them on a paid leave, you will get subsidized for the EI and CPP premiums as well. So it's almost like an incentive to call people back, put them on your payroll, but not have them do any work. I have a number of clients at this point, though, who I think are sick of sitting at home, twiddling their thumbs. And so they've been going to the office and starting to get things ready for reopening. And they've been calling their staff members in to do some active service. Certainly they're not calling hygienists in to do hygiene work, but they're just calling any of their staff members in, anyone who wants to come in and do work. They've been polling their staff and having people come in and pay them, and they're paying them wages, and they're utilizing the CEWS program to get reimbursed for that. Back to that layoff period that everyone is starting to worry about, what I've done here is compiled a table. I know that we have attendees right across the country listening in right now, so I've taken the liberty of putting this table together showing the layoff period for each province. Okay, and so you can run through that as quickly as I can, but you'll see in some provinces, for instance, Ontario, it's 13 weeks out of 20. And if you laid your staff members off in that first week that COVID was announced, or the pandemic was announced and the shutdown in dentistry occurred, you are starting to butt up on that 13 weeks, okay? And it's coming quickly, and you're gonna need to do something to deal with it. If you are lucky enough to practice in Manitoba or Saskatchewan, you don't have that same worry right now because those layoff periods have been extended during the state of emergency. So until the state of emergency is lifted, you don't have to worry about it as much as a dentist in Ontario, for instance. And then BC, they've just given you an extra 3 weeks, but that date will come at some point. And if you haven't dealt with your staff members at that point and you're not back to work and you haven't opened up fully and you haven't called all of your staff members back, you're going to need to deal with these issues so that you don't run into a situation that could potentially be catastrophic for you. I've seen over the last number of weeks documentation being sent out in the dental community where it's being recommended there's easy solutions to these issues. Okay, so the easy solution being, well, you know, simply ask your staff member to consent to extending the layoff period. That is great if you live in a fantasy world where your staff members are actually going to agree to that, because they're not, right? They're not. It's not going to happen. So if you don't get their consent and that layoff period expires, it is an automatic termination of employment. Okay, and you don't have a lot of time to engage in that back and forth with your employees. And I think it's no secret that there's a number of employees out there in any industry, dentistry included, who would rather get a payout than work. Okay, and so if you think that you're going to simply get the consent from your staff members to extend the layoff period, when they've done the math and they know what they're entitled to upon a dismissal, then like I said, you're dreaming in Technicolor, because it's not going to happen. So you can, and then of course, as I said, we have attendees from other provinces. You're not even allowed to extend it in certain provinces just on consent. So in Alberta, for instance, you have to give an additional payment to extend it. So it's not as simple as just simply saying, listen, I had to lay you off. I don't have work for you to call you back. So why don't we just agree that your layoff is extended until I have work for you to return? It's not going to happen, I don't think. And of course, they're not required to accept it. A staff member has the right to say no to an extension of their layoff period. And if they say no and you haven't done anything to deal with it and the layoff period expires, you could find yourself in a world of hurt. I've put together a couple of key dates I just want to go over before we get into our Q&A, and I want people to keep these in mind. March 15th, that week, somewhere in there was the date that most clinics shut down, and then that was the date that most dental clinics laid their staff members off, or somewhere during that week. June 14th, which is a date that again is quickly approaching, would be 13 weeks from that date. So if you're in Ontario or in Newfoundland and Labrador and you're listening to this, that's your maximum layoff period. That week is coming. If you're in other provinces, it might be a little bit later, or it might not come at all if you're in Saskatchewan or Manitoba. But again, you need to keep in mind that that date is quickly approaching if you need to deal with staff members who are on layoff. July 5th, again, if most of your staff members were laid off in that first week after dental clinics were effectively shut down, and they applied for EI benefits and were subsequently transitioned over to CERB, those benefits are going to expire somewhere in that week starting July 5th. That would be 16 weeks out. And then again, as I mentioned earlier, August 29th is the current scheduled end date for the CEWS program. So what we've been recommending to a lot of our clients is utilization of the CEWS program. It can be utilized retroactively. And you can do that to your advantage in certain circumstances. Now that it's been announced that it runs to August 29th, it's probably not as important that you utilize it retroactively, and I'll explain that a little bit later as well. But certainly when the programs were first announced and we had no indication that the CEWS was going to be extended, a lot of my clients did utilize it retroactively because it wasn't really an out-of-pocket for them, and they could use those retroactive weeks against the weeks of layoff that had already accrued. Okay, and then one other key point about that, and I'm getting this issue pop up a lot over the last 2 weeks, is employees saying, well, I don't want to go on the CEWS. I'm happy enough to be on the CERB. It's not taxed at source, so I'm getting $500 in my pocket. And, you know, if there's some sort of string attached that I need to come in and help you do admin work, I'd rather not. I'd rather just stay on the CERB. It's important to keep in mind that as the employer, the ball is in your court. Employees cannot say that they do not want to return to work unless certain circumstances are met. But if it's just, you know, I prefer to be at home, that is not a valid work refusal. And if an employee did that, you would be within your rights to revise their ROE so that they don't get the CERB at all. Okay, and now most employers are not doing anything that drastic right now because they're trying to maintain as much goodwill as they can with their staff members. But frustration is building on that point. Like I said, a lot of dentists are trying to get staff members back in so that they're ready to go and that they hit the ground running when the clinic opens. And if they're getting resistance from people saying, no, not for me, you know, I like it, the sun's now shining, it's beautiful the last little while, I'd rather just stay at home. You do have tools in your toolbox to deal with that as an employer. As I had said, certain situations will allow an employee to stay at home. The big one that comes up over the last little while is childcare. As we know, schools and daycares are, well, for the most part, shut down. And so there is protected leave under the Employment Standards Act for employees who cannot return to the work because they have to care for children due to the shutdown of schools and daycares. And that might be the case for a vast amount of employees in dental offices. And that's going to require quite a workaround as dental clinics start to open up, but schools and daycares don't. And so that gets us to where we are today for the most part. And I'm ready to start answering questions.
Okay, good. Paul, as you were talking about the CEWS, several questions came in that all relate to basically the amounts that are allowed to be applied for under the CEWS and asking whether there is a cap if the CEWS is used as a method to apply. Then the questions are, A, can I bring my employee back on CEWS without them agreeing to it? I think the answer to that is probably no, but you will know. You'll be able to tell us. And then how can I bring them back? It's just the maximum of $847. And if their wage is higher than that, then what do I do? How do I manage that with them when they're used to making more?
Okay, so question one was, can I call them back on CEWS? And what if they say no, I think is basically the question. And again, as I had said, it's your right to call them back on CEWS. The government is asking employers to call employees back off of layoff and put them on the CEWS. So the employee does not have the right to say no. If you call them back and place them on CEWS because you're worried about that layoff provision or the time frame expiring and it potentially causing, or will actually causing, a termination of employment, you should be calling them back and placing them on your payroll and getting the subsidy, and they cannot say no. Now, the numbers, it is a bit of a numbers game at the end of the day, because based on the amounts that you're able to pay your staff members right now without having income come in, there are certain circumstances where your 75% of their pre-COVID earnings will result in a payment of less than $500 on CERB. And you do get a lot of staff members saying, well, that certainly doesn't work for me because I don't want to all of a sudden be getting $350 when I could otherwise get $500. And so we've been working with employers on that issue. If you truly don't have work for that individual to come in, what we've been saying to them is, well, why don't we do it this way? Why don't we agree that you can continue to receive your CERB as opposed to me putting you on CEWS? But the consideration that I want in exchange for that is that you agree that the layoff period can be extended. And so that's one way to deal with that situation. But ultimately, if a staff member said, well, no, I don't agree that you can extend my layoff, and I don't want to come back on CEWS, as I said, you have a hammer in your arsenal. You can call them back and put them on the CEWS, and if they resist that return to the workplace, you could potentially deem it as a resignation. And if a worker does not return to the workplace, they will not continue to get CERB unless they don't return based on certain circumstances. Okay? The second part of your question, can you just reiterate that again for me, please?
It was, what are the caps on what they can claim? Because some employees, when they do come back, and this is one of the questions that's a common theme, I'm bringing my people back. I can't bring them back at the same hours and at the same wage. So how do I handle that separate and apart from the question of CEWS or CERB? If they are willing to come back and they come back, how do I handle bringing them back on fewer hours and lower wages?
So again, the CEWS will pay an employer a maximum of $847. That's it. Now, if we're looking at a situation where dentistry is up and running again, and you want to call a hygienist back, for instance, and hygiene is actually up and running again, and you want to call that individual back, but you only have $847 of work for them, then you'll pay that amount of money and you'll get reimbursed through the government for the full $847, so long as their pre-COVID earnings were more than $1,129. Okay, but if that's all you have, then that's all you have. And one of the big issues that is coming about with respect to that, and I think that this is going to be, it is going to be a large issue for dentists moving forward, is staff members saying, well, you know, I played ball while the clinic was shut down and I accepted my layoff and I didn't kick up a stink about that. But now that you're open and running again, I want to come back and be paid more than what you're able to access under the CEWS. I want more than that $847. I was used to earning $1,500 a week. So how do you, Mr. Dentist, think that you're going to be able to call me back and only pay $847? And it's going to create some interesting situations moving forward because, again, in normal circumstances, in a world where we're not dealing with a pandemic, had you not had enough work for your hygienist, well, then that's your problem, not hers. Okay, and if you had reduced that hygienist wages by $800 or $700 a week, you'd absolutely be facing a constructive dismissal claim. Absolutely. But in a world where that is a result of something that is no fault of your own, I think it is going to create an interesting line of cases as these matters start going through the courts. Hopefully none of my clients are the first test case for it, but it's going to create an interesting argument. Why should this be considered a constructive dismissal when it's through no fault of my own that I don't have the work for you? And again, these guidelines that Bill had alluded to previously, these guidelines have come out now in terms of how dental clinics are going to open. And, you know, they say, for instance, that you should look at bringing your staff back on a staggered basis and that you need to practice proper social distancing in the workplace. So based on the guidelines that you as a dentist are going to have to follow, it's just not going to be practical to have all your people back and all of them working at their regular hours. And so, like I said, it creates an interesting situation because how should you be the one left holding the bag on a constructive dismissal claim if you simply cannot operate in a way that gives them their previous COVID hours? So, and dentists will have to make a choice. Do you dip into your own pocket again, like I said, and start paying people at their pre-COVID amounts so that you take the most cautious approach whatsoever to dealing with a constructive dismissal claim? Or do you say, you know what, I don't have the money, and if you want to fight me over it, I guess we're going to have a fight. But it's a fight I see dentists likely winning if that fight has to happen in the courts in the future, at least on an interim basis. Right? If you're shut down on an interim basis, not shut down, but you're practicing with restrictions for 3 or 4 months, I think the courts will likely give dentists some leeway during that 3 to 4 month period on potential constructive dismissal claims. Now, if you use that as an opportunity to reduce someone's wages forever, simply because you didn't like that individual or you thought that they weren't a fantastic hygienist, you'll certainly run into problems there. So as your operations continue to ramp up, you'll have to continue ramping up your employees' wages along with it.
Okay. What if I have benefits for some of my employees? Does that change anything?
Yes, it does. Now, I will say amongst my clients, they're few and far between who actually maintain insurance benefits for their staff. But if you do have insurance benefits for your staff, then there's a very easy way that you can extend a layoff period and not even have to utilize CEWS. You would simply maintain those benefits for them, which would allow you to extend the layoff period from 13 weeks to 35 weeks, so long as you maintain those benefits for that 35-week period.
Are there other conditions that allow me to extend that period beyond the ones that you've just mentioned?
The easiest one that we just discussed would be to get their consent. But I just do not see that consent being given easily, simply because the dentist asks. And let's look at why that consent is not going to be forthcoming in certain situations. Let's say that you have an employee who's worked for you for 12 years, and you didn't have the good foresight to put contracts in place with your staff members prior to COVID. And so you don't have a provision in an agreement that restricts the amount of notice you need to provide to that individual upon a termination. And so they will be entitled to what's known as common law damages if they're let go. Common law damages for a wrongful dismissal are typically in the vicinity of a month per year of service. So taking that employee who's worked for you for 12 years, if you terminate their employment, they could be entitled to up to 12 months of pay. So now we have this 13 weeks in Ontario about to expire, and you go to your staff member and say, listen, I need you to do me a solid, okay? I don't have any work for you, so I just want you to consent to extending that layoff period. That individual will likely turn around and say, no, I'm not going to consent. I'll allow the 13 weeks to expire. It's an automatic termination of employment. And there's any number of lawyers out there who will tell them, I don't get paid until you get paid, and they'll take it on a contingency basis and you'll get sued. Okay. And that is the major risk with engaging in that discussion with your staff members about extending the layoff period. And you don't want to get into a situation where you make that proposal and your staff says, I'll think about it and I'll get back to you in a week. And then you're chasing them around for another week. And all of a sudden, you've only got a couple of days before that 13 weeks expires. Don't do that to yourself. You can ask, but if the answer is no, you need to deal with it quickly. Okay, don't keep hounding them and saying, did you think about it again? Come on, do it for me. It's not going to happen. If they know that there's money in the bank through a lawsuit for a wrongful dismissal, there is a large majority of staff members who are going to take that option as opposed to helping you out.
Even if it means that they may be giving up a full-time job.
Yeah, of course. There is a type of individual out there that would rather get 12 months pay out of you than to go back to work. Okay, and so the longer that individual has worked for you, keep in mind, the more that common law entitlement grows. So you start dealing with staff members who've been with you for 20, 24 years, all of a sudden you're looking at potential lawsuits where they could get 20 to 24 months of pay. And a lot of people would rather take that option than to go back and work. It happens all the time outside of COVID. Okay, so you deal with a situation frequently as a lawyer where you have to make some changes in the workplace for whatever reason, and you seek the consent of the employee to make those drastic changes like reducing hours or whatever it may be, and the staff members say no. They say, I don't want to work. I'd rather just get a payout from you. So they turn around and they quit and then sue you for constructive termination. So this could, if it's not dealt with properly, represent a fantastic opportunity for an employee who doesn't like working and would rather take money from you to sit at home. Okay, and to finish that point, those of you out there who have exercised the foresight at some point in the past to put contracts in place with your staff members, this is an abject lesson in why you should have done that. Because if you did it and you did it properly, you should have a provision in an agreement with those staff members that will restrict the amount of notice you need to provide to that individual upon a termination. And it should be restricted to the employment standards legislation in your province. And going back to Ontario, and simply because that's the jurisdiction I practice in the most, but the legislation is for all intents and purposes the same across the country. Those amounts are drastically different than the common law amounts for wrongful dismissal. And so in Ontario, it's a straight formula. If someone has worked for you between 0 and 3 months, then the amount of notice that they'd be entitled to under the ESA in a properly drafted contract that limits the notice to the ESA would be nothing. And then between 3 months and a year, it's a week. And then between 1 year and 3 years, it's 2 weeks. And then it grows by a week per completed year of service thereafter to a maximum of 8 weeks. So again, you talk about being in control of the situation moving forward. You know, if you have a staff member who is saying, no, I'm not going to consent to a layoff, and they have a contract in place, I guess at the end of the day, so be it. Like, if you've been with me for 4 years, I suppose I owe you 4 weeks, and now you're going out into the worst job market since the 1920s. So good luck to you.
Mm-hmm.
Okay.
Okay. A related question to that is, can I dismiss an employee who is laid off but still within their probationary period? So
Yeah.
that's what you were just saying,
Yeah.
between the 0 and 3 month period.
That's right.
And yes.
Yeah, simple enough. And the date of termination would actually be the date of layoff, so that they're not accruing service over that layoff period.
Mm-hmm.
So you would have, so long as you have a contract in place with that individual that limits the notice to the ESA, you would have no liability to that. And even if you don't have a contract, you know, for the most part, the liability is of such a low level that it's not likely that individual is going to pursue you for any more money in most circumstances.
Okay. What do you recommend for staff that have been placed on CEWS and now with returning to work have said that they're not able to come back due to health, mental anxiety, fear of COVID, or other related issues? What are my options in that case?
So there, amongst the examples you gave as to why someone wouldn't come back, the answer might be different. So if someone says to you, I can't come back because of my health, for instance, I contracted COVID and I'm still dealing with all of the symptoms of that, then you're not going to be able to call that individual back. Likewise, if someone was off during this period of time on a layoff and they had the great unfortune of being diagnosed with cancer and they're asking for more time off, you're going to have to give them more time off. Those are protections that they'll be entitled to under the Human Rights Code. Okay. Now, if someone says to you, I'm not coming back because I'm scared of catching COVID, that's not really a legitimate reason for them not to return to the workplace. Okay. Everyone is fearful and they're anxious about going out and catching COVID, of course. But that, you know, so long as you are operating your dental practice pursuant to the appropriate guidelines and you're following those guidelines, someone can't say to you legitimately, I'm just too scared of getting COVID, so I'm not coming in. To me, that would be a resignation. Now, where we'll likely find ourselves is somewhere in a more of a gray area than that. A KG staff member, and I hope none of them are listening, but a KG staff member would say, I have such a high level of anxiety around COVID that it is causing me an anxiety issue. And by the way, here's a letter from my doctor that says I've developed an anxiety condition because of this, and I need an accommodation on that basis. And if someone presents to you in that fashion, then like I said, they'll likely have a protection under the Human Rights Code, and you're going to have to play ball. If anyone does present to you saying they can't come back because they're anxious or because of their health, you still have the right to have them prove that to you and have them engage in the accommodation process with you. And the accommodation process under the Human Rights Code is a two-way street. You don't just say it and get the accommodation. They would need to provide you with the appropriate documentation and information to allow you to gauge the accommodation request and whether or not it's an accommodation that you're prepared to provide. And a leave of absence is an accommodation under the code.
Okay. What about employees who say that they cannot come back because they have childcare issues? And you alluded to this earlier.
Those employees will be entitled to not return to the workplace. And you will have to protect their jobs for them. Okay, schools and daycares are shut down. And if people do not have alternative childcare through, grandparents or whatever it may be, then you're just going to have to play ball, and you're going to allow them to take more time off, and you're not going to be able to fire them or to fill their job using someone else and not return them in the future. They will be entitled to that protection until we hear otherwise. So until daycares start to open up again, or come September when, fingers crossed, schools open again, you're probably just going to have to let those people stay at home.
Okay, and in that case, do we ask staff for a letter stating that they cannot come back to work for those reasons?
Yes. I'm a firm believer of reducing everything to writing unless it's going to prejudice you.
Okay.
Okay, so yes, any request not to return to the workplace should be substantiated in writing. And, back to, for instance, that situation where someone is seeking childcare. I was dealing with a client this week, and the employee, so they're starting to come back and get people to come in and do admin work so that they can hit the ground running. And an employee said, well, I don't have childcare, and for that reason, I'm not going to come in and help you out. And keep in mind, you need to have my job protected for me during this period of time. And my client said, well, yes, but I know that you live next door to your grandparents or to the children's grandparents, and they're their caregiver all the time, when in normal times when you're coming to work. And so they've engaged in this dialogue back and forth, basically, with the employee, saying that you need to give me some other reason. Like, I know you have access to childcare. And of course, the answer is, well, I don't want my parents or the children's grandparents coming into contact with my children because they could be immunocompromised or whatever reason it might be. So, I mean, ultimately, I think you're just going to start hitting your head against a wall with any staff member who says they want to stay home because of childcare.
And what happens to, how is the layoff window treated in these cases?
So that wouldn't be a continuation of the layoff period. That would then be a leave of absence, okay? And it's a leave of absence that they're entitled to, but the 13 weeks or whatever week period it is in our other jurisdictions, 16 weeks in BC, for instance, that period of time stops, essentially, and they're then on a leave of absence, and you would issue a revised record of employment to that individual utilizing the code for leave of absence.
Okay.
Right now they're on a layoff, and the ROE code is for a layoff or shortage of work. So once that happens, you would transition them over to that, and that's it. And then it's up to them to return to the workplace at some point in the future.
Okay. And if an employee refuses to return to work, how then do I revise the ROE?
If they refuse to return to work and it's
not for that reason, for any other reasons. Yeah.
Illegitimate reasons.
Yes.
Or the reason of, I like being at home and I've realized that the dentistry profession wasn't for me, and I'm going to take a me summer and I'll figure myself out and I'll get back to you. You just treat it as a resignation. Change the code of the ROE to quit, and that's it. I mean, they won't have any recourse against you. Again, it's like any other situation. If you have someone who's away from the workplace on a layoff in normal times because you had a downturn in business and you call them back to the workplace and they don't return, that's their problem, not yours.
Okay.
Okay.
Mm-hmm.
And I'll add one point to that, Farah.
Yeah.
In normal times, if you were to have a staff member on layoff and you called them back to the workplace and they didn't return, you could have a situation where at some point you receive a letter from a lawyer or a statement of claim served at your office claiming that you've constructively terminated that person by placing them on layoff in the first place. And that's why they didn't return to the workplace. And that does happen. I've had that lawsuit a number of times. But going back to the outset of all of this, and this was the big hot button issue back in March and early April, can I lay my staff members off? And the answer is, I can't envision why you couldn't have done that at the time. And my opinion on that hasn't changed. Okay, because here we are almost 11 weeks later. What was your alternative? You do have CEWS now and you can utilize it retroactively. Great. None of that information was available to anyone in mid-March. And so dentists made the decision, for the most part, to lay their staff members off. And I don't think that that has caused a constructive termination claim for 10,000 dental employees in Ontario or 50,000 across the country or whatever it may be. I don't think that dentists are sitting ducks for those types of claims, especially if they have taken steps to utilize the programs as they became available.
Okay, but there are several questions coming in from dentists who did not and still have not applied for the CEWS wage subsidy and are asking whether they can apply now, whether they can apply retroactively, whether the employee can receive CERB as well as CEWS at the same time, and what are the rules around that?
So yes, you can apply now. And yes, you can apply and receive retroactive. So you can go right back to the date of layoff. If you have that cash sitting around and you want to float it for the couple of weeks that it takes to get your subsidy back, you could go back as far as you want. You don't need to per se at this point in terms of the layoff extension. Like if you just called them back on CERB or CEWS, sorry, starting on June 7th, the next period, that will be enough to disrupt that layoff of 13 weeks. And then if you just rode that out until August 29th, you would chew up the entire layoff issue.
Period. Yes.
Layoff is 13 weeks in a 20-week period, keep in mind.
Mm-hmm.
So if you put them back on payroll on June 7th, then that 20-week period will expire sometime in early March, meaning that if you get to August 29th and then we have COVID 2, the sequel or whatever, the reckoning, and you need to place them back on layoff again, you'll be starting fresh because you've exhausted the initial 20 weeks, the 13 and the 20. But if you wanted to go back retroactively because you want to be good to your people and you want to make sure that they get more money in their pocket, then that's something that's available to you. And certainly I would urge any dentist to explore that. Okay, because it could help foster some goodwill during this rough time for a lot of people.
And can an employee receive both CERB and CEWS at the same time?
It depends, a classic lawyer's answer. Yes, in certain circumstances, to my mind. Okay, so keep in mind that the CERB was amended so that employees could receive up to, and I'll just use weeks because I like using weeks better, $250 per week during the CERB period and still maintain the CERB. Okay? So there's a cutout there for receiving some money and keeping your CERB. And there's some confusion out there in terms of dentists saying, well, why don't I only give my staff member $250 per week and allow them to keep the CERB, and I'll get the CEWS for the $250. And I've created a situation where my staff member is getting $750 in their pocket through the two programs, and no one comes out worse because of it. I think you can do that in certain circumstances. On a daily basis, I read something from an accountant or from another lawyer potentially who says, no, you can't do it, you can't get both. And to that I say, well, why? It's right there in the legislation. And it's right there. If you go on the government's website, the CERB website, it's right there. You don't lose the CERB simply because you receive some money. And nowhere does it say that an employer who pays a sum of money of $250 or less won't get the subsidy from the government. So there are certain circumstances where someone can get both. Where I do see a problem with that is where someone wants to sort of rig the system so that people are getting more than they would otherwise get when they were employed. So for instance, you have a staff member who's part-time and earns $500 per week in the best of times. But you really like that individual. Maybe they're your friend, or maybe they're a family member or something like that, and not an arm's length family member, but a cousin twice removed or something. And you say, well, listen, what I'm going to do is I'm going to give you $250 and you keep the CERB, and now you're going to have $750 per week. I think there's something inherently wrong about that. And I expect that if you were audited in the future, the CRA might have a problem with that. But if you're simply doing it, so for instance, let's say that you have a staff member who earns $750 per week pre-COVID in good times, but you don't have any money to pay the 25%. So you want to only pay them 75% of that amount of money. Well, why wouldn't you just utilize both of those programs in those circumstances and just give them $250 instead of the 75% and get them as close as possible to their pre-COVID earnings using both programs? I don't see there being anything wrong with that. Okay, and to date, I've had a number of clients who have accessed the CEWS and done just that, and I haven't heard a peep. Okay. I haven't heard anyone being questioned about this, receiving a call from the CRA saying, well, what's going on here? You're paying everyone $250. Everyone is getting it subsidized who's done it, and no one is getting any problems yet. And
Yes.
I don't see them having any problems down the road either, so long as they're doing it in good faith and they're not, like I said, rigging the system so that someone's getting more money than they would otherwise get.
Right. It may just be.
I'm going to buy you a moment's time here, because what the audience doesn't see is you're trying to process about 110 different questions right now, and you're doing it really well. Paul, commitment to follow up on them. I'm still the guy in the corner, and you're going to have some work cut out for you. Because Far's been doing such a good job here, but I think several people have asked, and I know I've heard a lot, is what is an employer's, and so you can look at a few more, Farah, what is an employer's liability if their employee gets COVID? And there was a related question about going on to the, I forget the name, Workmen's Compensation Program is a
The
WSIB,
yeah.
the WSIB.
Yeah, so those are two questions I know some people have. If
you open up your clinic and you have a staff member who reports to you that they've contracted COVID, you need to get that person out of the workplace immediately. You can't allow them to come back. Then I think you would have an obligation to have all of your other staff members tested. Okay, and it might take a couple of days. You might have to look at not running your clinic for those couple of days. Okay, because if someone has been in the workplace and been in contact with other staff members and that person has tested positive for COVID, there's a significant chance that others in your office will have it, and you will have an obligation to stop the spread of COVID if you learn of that. So you would likely have to shut down the clinic for a couple of days, get everyone tested, and figure out where you go from there. Let's also say that you have a staff member who comes to you and says, I'm not feeling so hot, and I need to take some time off. And I'm going to get tested. You would, of course, send that person home immediately. You would have them get tested, and you would tell that staff member that they have an obligation to share those testing results with you. Okay, and of course, I think you would even tell your other staff members in the interim that a staff member has gone off. They think they're experiencing symptoms of COVID. So, use your best judgment, but you should probably go get tested too. In terms of your liability to staff members who contract COVID in your workplace due to interactions with other staff or interactions with patients as they start to come back, WSIB is available. You won't be able to retroactively utilize it. So you won't be able to have a situation where someone contracts COVID and there are a bunch of claims against you for endangering their health. You won't be able to call up WSIB and say, I have a problem, I need coverage. You need to get it proactively. And we've been telling people, go get it. It's there, and it will help you in the event that your staff members become sick because of COVID and they turn around and try and point the finger at you. That's exactly what WSIB is for. WSIB is not all that expensive, okay? And I think it is something that, and whatever the workers' comp framework is in whatever province, but in Ontario, it's WSIB, I think you should seriously consider it and seriously consider putting it in place. Because, and just to finish that point, I think it would be quite a nasty situation if you have a staff member who contracts COVID-19 in your workplace, no matter what, right? I mean, if they suffer some serious health consequences because of that, they're going to come looking to you. And you can make any argument that you want about having proper PPE in place and taking all the proper protocols. If someone's health is seriously endangered because they've contracted COVID-19, they're not just going to accept that. Okay, so like I said, I think you need to explore that option.
Thank you. We spent a lot of time talking about CEWS and CERB, and there are still many questions around that topic, but I want to switch tack a little bit to address some other types of questions, which are questions regarding contracts. So in cases where contracts were not in place, the questions are, this seems to be a golden opportunity not to be missed to implement employment contracts if I haven't done so before COVID. Can I impose contracts now? If so, how would I go about doing those if I did not previously have them?
That is a great question. And it's one that I've been receiving a lot over the course of the pandemic as dentists start to realize why it's so valuable now to have contracts in place. Okay, because if you have contracts in place, as I said to you earlier, you're protected. If you have a provision in there that says, I only owe you the employment standards legislation notice upon a dismissal, your worst case scenario is not truly a worst case scenario. You're exposed to, weeks of pay to an individual. And at the end of the day, I know no one wants to pay that out when you don't have income coming in, but there's not a lot of money in the grand scheme of things. Also, a good, well-drafted contract should have a provision in there that allows you to lay your staff members off. And so all of this confusion at the outset of the dental clinic shutting down about, well, can I do it? Will it be a constructive termination? You wouldn't have any of those concerns if you have a contract in place with your staff members, because you'd be entitled to do it. You wouldn't even have to worry about that. And then again, back to that point about termination, even if you didn't have the layoff provision in there and someone takes the position they've been constructively terminated because of the layoff, here's your weeks of pay. Good luck out there, and go on with it. So dentists are realizing the benefits of this now, and most dentists at some point, I think, do realize it, but some of you out there are procrastinators and you haven't gotten it done. So is it a good time to do it now? It depends on the situation. A part of me thinks it's a bad idea, okay? And the reason being that there's so much anxiety out there and people are just, they're hurting, right? That they don't have income coming in and they're getting the CERB, but at the end of the day, that's not a king's ransom of money. That's not going to sustain people for much longer. And it's certainly, you think about a family who has, 3 children and they're, you got to put food on the table and you've got a mortgage and maybe you can get it deferred or whatever, but it's stretching people very, very thin. And so if you were to say to your staff member, I think you need to sign a contract and I want you to sign one. And if you don't sign it, I'm going to provide you with notice of termination of your employment, because that's often what is advised to dentists to do. Okay, sign this contract and I'll give you some form of consideration to sign it. But if you don't sign it, I'm going to give you working notice of termination based on your years of service here. And at the end of that working notice period, you're done. I think that if you go down that road with a staff member and they sign the contract and they take your $250 consideration in exchange for signing it. I think you have created a very strong duress argument for staff members. And duress is a way that employees can get out of contracts to say that I signed it under duress, or I signed it, I was coerced into signing it. So is it a good time? Theoretically, it represents a great time to do it because you've got the admin time now to deal with it. But I would caution any dentist going down that road, because I think it would create a neat little argument for a plaintiff's lawyer going forward that contract was signed under duress. Okay, so and I'm not saying that it's wrong in every circumstance, but look before you leap. Okay, and get advice about this if it's something that you want to do. And there's never, ever a one-size-fits-all solution when you're dealing with your staff members. So I think it would be cavalier to say, you know, now's a great time. And look, I told you so. You should have had contracts in place, so you got to get it done. I think that is a bit short-sighted, to be honest. And whenever we deal with contracts and implementing contracts in dental offices, you know, we like to get down to the nitty-gritty as best we can with each individual staff member in each office to determine how is it best to deal with that individual staff member. And I think that holds true in these circumstances, probably even more so. So certainly if it's something that you want to explore, by all means explore it, but don't just start it without getting help. And don't just, you know, think that it's going to be a cakewalk because no one's got anything else to do.
Mm-hmm.
Okay, and also,
Okay.
if I'm a staff member and you approach me right now with a contract, no way on this earth I would sign it voluntarily for a pittance of money in exchange for signing, because employees now probably more than ever will know their rights inside out from an employment law perspective, because they've had to deal with a significant amount of turmoil throughout this whole process, okay? So I don't think you're gonna get a lot of luck in having people sign to begin with.
Okay, so the message here is get some professional advice, and maybe people might reach out to you, plug, if they want that advice. Paul?
Yeah, and just to come full circle on that point, you know, that the process of putting contracts in place with your staff members by maybe not giving them something in exchange for signing, but by giving them this working notice and saying to them, here's your contract, in X amount of months of time, your employment on the current terms is going to end, and you're going to have to sign this agreement if you want to stay on with my clinic. And that working notice period happens to be, I don't know, 15 months or something like that. And we're well out of this pandemic by that time, and they sign. Fine. Maybe you've got an enforceable contract with that person. I would also caution dentists about disrupting the goodwill that they have with their staff members by doing that, though. Okay? What's the rush? Why do that with them right now and tell them that you're backing them into a corner to sign a contract at a point in the future? Like I said, you know, your people are stressed out enough as is, and, you know, make no mistake about it, I advocate on behalf of employers. And I'm not advocating on behalf of staff members who happen to be stressed out and don't cause them any more stress, but that might bite you in the butt at some point in the future. Okay, in terms of, let's say that you want your people to come back and work reduced hours, and you want them to consent to working reduced hours. Well, if you've gone around and provided them with working notice of termination, and that termination is going to happen maybe at some point in the future, what incentive is there for them to play nice with you? Okay, so like I said, no matter what way you want to implement those contracts, or you're advised to implement those contracts, be very cautious about what you do.
And do you suggest the same for changes to existing employment contracts? Caution?
Depending on what those changes are, absolutely. And as I said, I mean, at this point, if you've taken advantage of the programs that are out there for you, so that you've disrupted this layoff period, and why are you putting contracts in place right now? I mean, I know that some people want to do it, and maybe in certain circumstances it's appropriate, but to what end? Why not just wait until you're back and you're operating at a more normal capacity and then revisit the issue? Like, to me, at this point, to rush to put contracts in place is like racing towards a red light. Where are you going? It doesn't make a lot of sense to me at this point, unless, there are particular circumstances that justify it.
Mm-hmm.
So it's one of those things you should have had it done, and you should get it done, but you should seriously think about when you do it.
The point Paul's making is, I think, critically important. It's easy when we get into discussion of employment law issues to think only in terms of the adversarial relationship. And Paul, that's sadly what you get involved in a lot. But you made the point about goodwill with the staff a moment ago. The whole premise here is you all need to get your offices back up and operating as best as you possibly can in very difficult, uncertain circumstances with a wide range of people with different attitudes and responses. It's really important at this time that you do everything you can to work with your staff to make sure they're feeling comfortable, they're feeling motivated, they're feeling part of a team, and inevitably a bunch of you will struggle with some malcontents, and a lot of the legal advice is critical then, and having contracts is great. But don't let that fear override the business requirement and the just good people management principles of your staff need you, they need their jobs, and they're critical to your practice. And you need to keep that in mind throughout all of this. And Paul, I know you would not disagree with that as sort of an overriding principle, notwithstanding the litigious nature of some staff.
No, that's right. People often ask me, well, how do I avoid lawsuits with my staff members? Or, this petition that has been circulating about unionization in the workplace. And a question I've always received is, how do I stop a union from coming into my workplace? Well, the first starter should be good to your people and treat them well. That's the best way to avoid a lot of problems with your staff members. So back to the point about contracts, it could be a can of worms for you at this point. It sounds great in theory, but practically implementing agreements with your staff members, even if you get what you want, I think that you could just be creating another problem down the road for yourself.
Okay, we're at 10 minutes to 9. There are many questions, but there's no way we are going to get to all of these questions. I wanted to give you, Paul, an opportunity to say if there are issues that you feel are relevant, one or two things that you need to say just in closing. And we're going to have a lot of homework to respond to some of these questions over the next day or two. And also to Bill, if you've got any closing comments that you'd like to make.
My closing comments to dentists is to get good advice and get help in dealing with your staff members. Right now, the employment law landscape is a minefield, okay? And it is always worth it from an employment law perspective to get some help out front. Dealing with things proactively and making sure that you have your affairs organized is infinitely more, well, it's less expensive and less aggravating than dealing with things in a reactive nature and dealing with things once they've gone off the rails. And so keep that in mind. It's a lot easier to get on a call with a lawyer. I know that sounds like a shameless plug, but it's a lot easier to get on a call with a lawyer for an hour, to get your affairs organized and to get things worked out than to have to deal with a lawyer on a lawsuit and all of a sudden you got 50 to 100 hours in. Okay, so I'm urging people to deal with these situations. Don't stick your head in the sand, okay? Because these problems will arise, right? As this has gone on, these time frames are getting shorter and shorter. You need to deal with them. And similarly, as my last point, just back to, once you've dealt with this in the short term and you've put a Band-Aid on it and you stop these layoff periods from accruing, be very careful with staff members returning and their requirements about returning and questions you might receive about accommodation in the workplace, because we didn't get into that today, and that's a whole other hour unto its own. But there are potential ramifications under the Human Rights Code, and that is the Human Rights Tribunals. it's a place I always want to keep my clients out of, okay? Because it is a no-win situation once you get dragged in there. So just be careful. Any questions that you have from your staff members, if there's some uncertainty about what you need to do and what your obligations are, like I said, it's easier to speak to a lawyer for an hour or half an hour up front than to deal with it thereafter.
I think that my closing comments, there was one question I was going to address at the end. We had a couple of people say that, hey, the RCDSO is coming out with a new announcement, and I've heard that they're going to be backing off the requirements announced last Friday. So don't run out and spend money on things. And one person said to me, Bill, don't run a webinar on Friday with HVAC professionals. The reality is that is a rumor going around, and none of us knows. Or if you do know, you're in a better position than many people. So we have to keep open minds. We're going to announce something in that regard shortly. Our commitment is to try to find experts like Paul to help you with some of these startup issues, because getting your business back up and running is both very important to your bank account and to those of you who will be selling in the interim. It's going to be the most important thing people are going to want to look at. We'll try to get back to the people who ask questions. I would just ask that you all exercise some discretion. Everyone leans into these sessions hoping to get free legal advice. Paul, you were very good on not saying at the beginning a big sign saying this is not legal advice. Remember, he does this for a living. We've had a couple of people ask for samples of employment letters and employee agreements. Paul giving you those, or anybody giving you those, would be like a dentist doing work on a patient without properly doing a first exam and without charging them. So just remember that, and Paul's last comments were critical. We see people in trouble with employees all the time, and it now is worth a lot later. And Farah, we've got, as you said, our task cut out for us with all of those unanswered questions, many of which were answered, I think. So
many of which were answered, but there are angles on each one. Many questions with regard to the CEWS and CERB and just the administration of the application of those things, how they apply in individual circumstances. So we'll do our best to get back to you.
One closing point about what we've been doing with our clients in terms of CEWS is working with them and looking at each individual staff member. So while I'll commit to answering these questions as best I can, as I alluded to earlier, there's not really a one-size-fits-all solution for every staff member. So you might need to get some individualized advice. Certainly we can help with that, but anything that we can answer sort of on a hypothetical global basis, we will.
Yes, and thank you. I think that we are out of time. This was fun. It was very interesting, but I think we'd like people to get on with their evenings. And I thank you very much, Paul, and thank you, Bill, for your collective insights. We hope that we were able to answer some of your questions today, especially some of the burning ones, and we will endeavor to answer the remaining ones as best as possible over the next couple of days. Paul, I'm just going to share my screen so that I can
So that requires me to stop sharing, correct?
Yeah, yep. So if any of you would like to reach out directly to Paul or to Bill, I've put their contact information up on the screen. So reach out to them by email or by calling them. And Bill, there were a couple of questions about practice value, but I think we'll leave those aside for another session. And I think that's it. Anyone got anything else, Paul or Bill?
Have a great night, everybody.
Okay, this ends this evening's webinar. Thanks, everyone, and enjoy the rest of your evening.